Hey, 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 all persons standing before the office of justice of the appeals court now sitting in Boston, far within the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning.
Good morning. Thank you. All right, I'm going to begin by introducing our panel today. To my right is Justice Greg Massing. To my left is Justice Robert Toone. My name is Ariane Vuono. Before I call the first case and before I make any preliminary announcements, I want to welcome a class from Boston College Law School who's with us here today to learn a little bit about the appeals court, and good to see our good friend and a former colleague, Justice Andrew Granger, here as well. I want the students to know that we'll meet with you afterwards and talk to you a little bit about the appeals court, okay? So don't rush out on us. With respect to the people who are arguing today, you know that you each have 15 minutes to present your case. There is no rebuttal in the appeals court. And some of the cases have voluminous records, but you can be assured that we have gone through them quite carefully and that we know what you've provided to us, and so you can get right to your most salient points. So the first case here is Commonwealth versus Michael Tyson Jr., 2023-0229.
Good morning, Your Honors. May it please the Court, Karen Palumbo on behalf of the Commonwealth. The motion judge in this case improperly allowed the defendant's motion to dismiss, where the application for a criminal complaint, which in this case was the police report, which was attached.
I'm going to interrupt you. I'm sorry. I'm having a little hard time hearing you.
Okay,
so
sorry.
If you could just bring that microphone a little bit closer to you if you
Okay.
can, or lean a little bit into
Okay.
it so we can.
Okay, I will.
Thank you.
There was probable cause to believe that the defendant assaulted a police officer and he resisted arrest. The officer was investigating a stabbing that had occurred on the street earlier in the day, where the victim was med-flighted to a Boston hospital. He was canvassing the neighborhood, speaking to residents. He noticed an automobile, a black Lexus, which was parked, but the light, it was running. He approached. He told the individual inside that he was a police officer and said he was investigating a crime. He illuminated his badge so that the individual would know he was a police officer. The individual, he requested 2 times that he roll down his window. He didn't. At that point, the officer opened the door. The defendant.
Is that lawful?
That would be a question either for a motion to suppress or for the jury at trial, whether this detective overreached by opening the door.
Well, I mean, I think based on this record, and I know we have to give all the inferences in your favor, I just don't understand what authority the officer had to open the door. He certainly was entitled to try to make contact with the driver, certainly was entitled to ask the driver to roll down his window, but the driver, I believe, was entitled to say no. So what would possibly justify the officer then to open the car door?
Well, I can think of safety issues, but that wasn't raised. So all we're dealing with today are the 4 corners of the complaint, the application for criminal complaint. And it's whether those facts support probable cause that the defendant assaulted this police officer and resisted arrest.
I guess it isn't important to understand whether or not the officer acted lawfully when he opened the car door, because the act that you say is the assault and battery involved the defendant trying to close the door, right? Pulling
Yes.
the door shut. And apparently the officer put his body, he opened the car door, and he must have put his body in the way of the door being closed. So I think it is important for us to understand, why did the officer feel he could open the car door?
There's nothing in the police report to establish that except for the fact that he would not roll down the window.
Okay. If someone unlawfully opens your car door, are you allowed to close the door?
We're talking about a police officer, so not just a regular citizen. If someone came and opened my door, like my cousin, no, I could shut the door. But
If a police officer unlawfully opens your car door, are you allowed to politely close the door? Setting aside whether or not the officer has put his body in the way.
okay, I personally wouldn't. The police officer is trying to make contact with me, and the thing is, this was a non-coercive inquiry that escalated into assault and resisting arrest. But again, whether the officer was, out of line or it was unconstitutional to open the door, that is the question for motion to suppress, and it's something to be resolved either prior to trial or at trial. Individuals.
Why doesn't it have anything to do with why do you say that it doesn't have anything to do with the probable cause determination? Because if there was no justification, then there's also no probable cause to find that there was an assault and battery on a police officer, because there'd be no evidence of any intent or anything like that.
But we don't know what the justification may have been, and we're just simply looking at the facts as they are in the police report. And those facts say that the defendant hit the officer with the car door. Whether or not the officer opening the door was lawful and whether his pulling the car back was reasonable is something to be resolved at trial. This state does not have right to resist arrest, whether it's lawful or unlawful.
Well, we're just focused on the assault and battery. And the officer says in his report that he pulled the door into the left side of my body forcefully, right? Mm-hmm. Car doors only go one direction, right? They open, they close.
Yes.
You can't take a car door and throw it at somebody. So it was in the act of closing the car door. And I guess that's why I feel it's relevant for us to know what your position is on how this happened. And sort of, you may still be correct that this has to be reversed. I'm just trying to understand. It seemed like the precipitating event here was a seemingly unlawful act by the police officer to open the door and then to put his body in the front. It's sort of akin to opening a house door and then putting your foot in the threshold.
Yes.
And I guess that's my question, sort of, can you give us any more information as to your position on that?
All I have is that police report. I mean, I would direct your attention to Commonwealth v. Murdaugh,
Yes.
where the officers, state police, opened the door after the person in the vehicle was unresponsive to them. That was a community caretaking exemption. This police officer could have felt he was in danger. The windows of the vehicle were darkened, but I can't speculate as to exactly what his justification for opening the door was, other than he wanted to speak with this individual about the stabbing that had occurred earlier in the day. And I would suggest that even if the officer's conduct was unlawful, again, it's a subject for motion to suppress or at trial.
Can I just ask it a different way?
Sure.
The Commonwealth has to establish through the complaint probable cause for this crime. Now we're talking about ABPO, right?
Yes.
To convict, I'm reading your brief. To convict a defendant of assault and battery on a police officer, the Commonwealth is required to prove the defendant intentionally touched the victim, knowing the victim was a police officer, without any right or excuse to do so. So does this go to the without any right or excuse to do so?
It may, but I would still suggest that that is an issue at trial.
But I mean, do you have probable cause that he had no right to do so?
I'm saying that probable cause, the opening the car door was something that I can't say the reason why he opened the car door. And if it were, in fact, unconstitutional or illegal in some way, that is something that would be resolved at trial. Defense counsel would file a motion to suppress, or the jury would hear the facts that the officer simply opened the door.
If we reverse the dismissal and and the complaint goes back on, and he files a motion to suppress, and is successful, is there no evidence that you can prosecute
If the
him?
motion to suppress is allowed, yes.
Excuse me?
If the motion, I'm sorry, Your Honor. If the motion to suppress is allowed, yes, we would be unable to prosecute the case. Okay. I would suggest there's also sufficient probable cause for resisting arrest. He pulled away from the officer as he was trying to handcuff him. He continued to struggle. He refused to sit on the ground.
On that issue, so just to follow along with the chronology, according to the officer's report, he opens the car door, the defendant pulls the car door shut, the officer has his body in the way, and he gets struck by the car door. And then the officer says, I struck the male on the left side of the head and pulled him from the car. So I understand that resisting arrest, normally there's no right of sort of, physical resistance, but there is in the case of excessive force. So is that going to be, if we remand this, is that going to be an issue as to whether or not the officer was engaging in excessive force by striking this person in the head after
Yes.
being hit by the car door, and then he may well have been justified to come out and take a defensive position? Is that
Yeah.
possible, how this case can play out?
Yes, it is. But again, that is a question for the jury. If every individual on the street could react or respond in a violent way because they believe they're being wrongfully, touched or interacted, it would be disastrous. This is a question for a court of law, or the fact finder in the court, as to whether or not he used excessive force.
So, and when you recited the facts, you emphasized the pulling away and the refusing to sit down. You did not say the squared off with clenched fist part, because is that because he wasn't told you're under arrest until after that?
I guess so. I didn't write the brief, so I'm going to say that I guess that's the point. Yeah.
Okay, so maybe we should, because he says after the officer hits him, defendant squares off with clenched fist. I told him that he's under arrest and had to stop it. So it's only after that
Yes.
that we can consider.
It's the point
so
of
it's
arrest.
pulling away.
Yep. And then he did handcuff him. He again tried to pull away, tried to get something out of his pocket, and refused to cross his legs and sit on the ground for safety reasons.
And that was after he was handcuffed, that as well.
Yes, yes.
But the actions that amount to resisting arrest have to put the police officer in a risk of bodily harm, right?
No, well, there's a risk. I would suggest that any individual trying to resist arrest puts the officer in risk of serious bodily harm.
Well, no. I mean, if you say, I don't want to be arrested, don't arrest me.
No,
I mean,
yes, but a physical action in response to being
when you're
arrested.
handcuffed and you're refusing to sit down, is that resisting arrest? Like you're not. That's not. At
Well,
that
he's
point,
already
the
in
officer's not
handcuffs.
in
He's
it.
already arrested. So, but he's non-compliant. So maybe that fact doesn't add to the picture. But in any event, I would stress that the four corners of the complaint clearly show that the defendant assaulted this police officer and he resisted arrest. And I would ask the court.
Well,
Sure.
can I just follow up on that point? So just to read the officer struck the male on the left side of the head, pulled him from the car. He squared off with me in clenched fists. I told him he was under arrest and to stop resisting me. So that's when the arresting part happens, right? He attempted to pull away, but I handcuffed him. I attempted to place him on the grass behind and to the right of the car in a sitting position for his safety, and he attempted to reach into his front right pockets to get his cellular phone. So those are the acts, the attempting to pull away and him reaching for his cell phone that are really the gravamen of your resisting arrest, not the facing up with clenched fist
No,
beforehand,
I mean,
right?
and I would say simply pulling away from the officer after he's notified you that he's placing you under arrest is sufficient for resisting arrest charge. If the court,
Why are you pursuing this appeal? I mean,
I'm sorry, what?
Why are you just pursuing this case? I mean, this seems under the best light of these facts, it seems to be a very questionable encounter between the police and this person who was sitting in his mom's car in front of his mom's house and got, I'm just trying to understand sort of, this happened in 2019. What's the principle here that you're fighting for in bringing this case up on appeal?
just that there's probable cause to arrest in this application for complaint. And the rest of those issues are all issues for trial and for the fact finder. That's the only justification.
Okay. No further questions?
If you have no further questions, I'd ask that you reverse the motion, Judge, and remand the case to the lower court to reinstate the complaint. Thank you.
Thank you.
May it please the court, good morning. I'm here on behalf of Michael Tyson. Pleased to be here before the court this morning. Thank you. I guess if I might just shift the way I planned things, maybe I'll go to the resisting arrest first, because there's an important sequence there that Your Honors have actually already brought up. The sequence happens so quickly. My client is struck in the head, yanked out of the car. Anybody in that circumstance might briefly react and stand off, as the officer indicates. Nevertheless, at that point, after my client squares off, the officer says you're under arrest. And so then what the officer describes as, I think, he tried to resist, he's handcuffed. That's the key event, the handcuffing itself. And,
Well, he pulled away, right? The pulling away is the critical.
The pulling
Conduct.
away is critical, but the officer, within a sentence, and so we assume, because we have to work within what the officer has either said or hasn't said, that the pulling away could have been a motion with his wrists, but he's almost immediately he's handcuffed. And I believe the cases that are used by the Commonwealth that I would comment on, I believe it is, let's see, Lender and Mayotte. Those two cases kind of talk about a whole sequence of events. I believe it's Lender where the individual is running away, and eventually the officers have to overtake him. It takes 4 officers to secure him after some struggle. So there's a continuing sequence before the very arrest. But after he does run away, the officer says you're under arrest, and I believe he then begins to cooperate. Let's see.
You know, what
Excuse me, I could be citing the wrong cases. I believe it's Grant and Grandison. And in
fine.
Grant and Grandison, we have circumstances where there's a fair amount of events prior to the actual arrest itself. In one case,
I think the judge had a question for you.
Excuse
I take your point. I mean, the problem is this is a very difficult standard of review for you on just on a motion to dismiss. And it does say in the report, although he was handcuffed, he continued to be resistive. And doesn't give a lot of details as what that means, but there is some assertion there that he was continuing to resist in some way. Is that itself sufficient to allow this case to go to trial?
No, Your Honor, thank you. I'd say it's not. And I think the key thing, I believe, might have been brought up by Justice Massing, but there is a requirement under the statute, it's quite clear, that the activity in arresting should involve some sort of threat or should involve some activity which could threaten the safety of the officers. And I believe it's in one of these other cases where the court talks about this notion that continuing resistance, perhaps flailing, could put officers at risk. And so I think that's the distinction there, where Officer Cesarini here says he resisted, but I handcuffed him. There simply is not enough, even at the probable cause stage, to say that he was genuinely resisting arrest. Because once he's handcuffed, that's it. That's the event. Going to the
Before you get to the,
Sure.
Justice Vuono, did you have a question?
No, I was just going to say that conduct after you're handcuffed will not necessarily be precluded. It could be considered as part of resisting arrest, right? I mean, someone could still run away, someone could still kick, someone could still do things afterwards. I'm not saying that there's no allegations here, but it doesn't necessarily end the inquiry just because the person's been handcuffed, correct?
I would say you are correct, Your Honor, but I would say here that, again, the activities, even as described by the officer, are genuinely minimal compared to the cases that I've compared this with.
Yeah, I wanted to ask you about the resisting. One of the elements is that the police officer is engaged in his performance of his duties as a police officer. You're not arguing that the officer wasn't acting as a police officer.
I'm sorry, could you repeat that, Your Honor?
You're not arguing that the Commonwealth failed to meet that element of the
That he
crime.
was a police officer?
Right.
No.
And that he was, I mean, you sort of suggest that he was like outside of his duties or outside of his proper functions as a police officer. But he's.
That's a good point, Your Honor, and I cite for that proposition the Montez case. And the Montez case is kind of interesting in the sense that what goes on there is kind of a melee, and I believe that the defendant himself actually tried to stop the officer from arresting one of his friends. So the defendant's charged, and what I believe the court says in Montez, at best they might have a right at trial to raise defense of another. But that case does go on, and it actually goes on to to indicate, and of course it's dicta, but it does go on to indicate that there could be a circumstance where a police officer's on-duty conduct so flagrantly is divorced from any legitimate law enforcement function that he may no longer be deemed to be acting within the scope of his office. So there are circumstances where, even as suggested in the Montez case, where the officer could step outside of his actual duty. Now, we have a situation here where the officer, in somewhat, in his own language, indicates that he opened the door, which I'll get to, of course, we'll go back to that. He opens the door, and as my client tries to swing the door shut, pull it shut, the officer says, he struck him in the face and yanked him from the car. So, do we have a situation where an officer has stepped outside of his bounds? That would be my suggestion on that question, Your Honor. Thank you.
So you are arguing that he stepped outside of his bounds?
Yes, Your Honor. We line these things up in our briefs as best argument to the lower argument. And certainly my third argument here, and I cite the unnamed defendant case, and I think the Odell case is similar. Both of those cases talk about not only, there's some overlap, so where we talk about has the officer gone outside of the scope of his duties, but also is there a circumstance where the actions are they actually demean or discredit the justice system. And I believe that language is used in Odell. They talk about impairing the system of the grand jury. And in the other case I just noted, yes, the unnamed defendant, there's sort of an impairment of the justice process itself. It's easy to say, perhaps, that these things, put it all before the trial judge. Let there be a motion to dismiss. But the cases that we both cite, suggest this proposition that there is a purpose for the process, for the De Benedetto process, for the grand jury process, of course, which is to weed out those cases which go beyond the appropriate bounds and where a defendant really shouldn't even be exposed to the system at all. Going to the assault and battery, Your Honors were active in asking questions about the door itself. But what happened before that? The officer, I would say, had no right to open that door. He simply didn't. And Mr. Tyson had every right to ignore his request to do so. Now, we on practical terms, we come to the question, well, what does the officer do? Just walk away? Well, no. If we want to speculate what the officer does, we already know from the confrontation that the officer and Mr. Tyson could hear each other through the window, because the officer says, Mr. Tyson said, in response to open your window, Mr. Tyson said, what for? So they could hear each other. So at this point, under Murdaugh, which actually is discussed or was cited by Commonwealth, the officer goes to Chapter 90, Section 25. And that's actually footnoted in Murdaugh. It's important. The officer didn't in this case. My point is, an officer in these circumstances can go to Chapter 90, Section 25 with an individual in a car. Why is that significant? If you think about normal police procedure, at that point, the officer has a setup for what is essentially a criminal violation. If he says license and registration under Section 25 and is still refused, he has a right to proceed further, because that is a violation of the law. Of course, we also know here, not explained by Officer Cesarini because he didn't do it, but he certainly could have walked around and looked at the plates. I don't want to get too far down to things off of the record, but I also note the cases such as Umberto, where the court itself sort of goes off the record because they say, well, what's not in here?
Well, can we just jump ahead and just, let's assume for the moment that it was unlawful for the officer to open the door. And then the defendant's closing the door. How do we analyze this issue about the defendant closing the door with the officer's body in between the door and its closed position, right? I mean, that's where the supposed assault occurred, and I'm trying to understand what's your position as to what a person in your client's situation can and can't do under those circumstances. It's equivalent to someone opening a door and putting their foot in the threshold. Are they not allowed to close the door? I mean, because knowing that the door will strike the officer's foot. What's the rule on that? What should be the rule on that?
You know, I would say this: the opening of the door was illegal. The assault and battery requires an intentional touching. And the cases talk about the distinction between what could be accidental or inadvertent touching as opposed to an actual intentional touching.
That seems like a fact issue, though, whether or not the defendant knew he was going to strike the officer, or the car door would strike the officer when it closed, right? That seems like a fact issue that we can't assess on this record. But are you arguing that the defendant has a right to close the door even if the officer has put his body in the way there? Or I just don't understand your position on that.
Thank you. Yes, I do think while we don't, interestingly, the officer himself doesn't say in his report, I opened the door and put myself within the arc. So in drawing from what we have, the best we can assume is that and the officer does use the word pulled. So the best we can assume here, and I know we review it in light of the Commonwealth, but I think in light of my client with a door open where there was no right to do so, my client was simply closing a door, which I would say he had a right to do. And we also don't know what type of movement the officer engaged in. Was he going toward my client as he was swinging the door? Did it appear from my client as he took the door and pulled it that the officer was not quite there yet? We don't know because, and as I pointed out in Umberto and some of these other cases, we can make inferences from what we don't know, from what hasn't been included in the report. But I would say that my client, Mr. Tyson, had the right to close his door. And I think to impose there, when it's a movement of one object that itself does the touching, to infer there an intent there's just not enough there compared to some of the other cases. There's just not enough there to infer an intent. And that's where this very quickly sequence of events just begins to cascade.
Couldn't you reasonably infer an intent also from the fact that your client had declined to put it more strongly, refused to roll down the window and talk with the officer in a more collegial, way, let's say, instead of talking through the window, through the closed window?
Thank you, Your Honor. I think all we can infer from that is he had determined to not be cooperative. And I would suggest, again, the circumstances late at night, my client certainly, we don't know this from the record, that either party was afraid because of, the fact that it was nighttime, afraid of each other. But I think, one could infer his refusal to cooperate could be because of the same circumstances. But that's where we look at whether or not he has a right to not. I mean, you could say, I think all you can infer from that, Your Honor, thank you for your question, is that he was uncooperative. I think that's the best. And the officer already knew that.
Which obviously, in your view, is not enough for probable cause to establish a probable cause for any of the elements of the offense.
Yes, I would say that, Your Honor. And of course, the officer already knew that he wasn't being cooperative. So the officer went a step further, a step too far in opening the door. And it was opening the door and striking my client in the head that accelerated the entire situation. So that's right. I think we know he wasn't cooperative, but I think that's the most of it. And where the officer to have taken appropriate steps with that lack of cooperation, which were available to him, including Chapter 9B, Section 25, the right to request identification, look up the ID. The officer had plenty of procedures to diffuse rather than to really accelerate this situation and physically accost and bully my client. And that's our position. Your Honor, my time has run out.
Your time is up, but I'll still check to see if we have any questions from the panel.
I have one question that I'm just looking at the record. The complaint has 3 charges: resisting arrest, ABPO, and disorderly conduct. What happened to the disorderly?
Commonwealth decided not to pursue that.
Okay, thanks.
Thank you.
No,
you.
thank you very much. Thank you both.
you.
We'll take the case under advisement. I think we have both people here for case number 2. Is that correct? Great. And for 2? Okay, perfect.
Case 2, step forward, please.
Yeah.
And ask all parties to please make sure you vote on silent.
Yeah. So I'll call the case, Commonwealth versus Martin McDonald, 2023-0019. I'm glad everybody was able to get here today.
Good morning, thank you. May it please the
Morning.
court, Laura Yashulis for Martin McDonald. Your Honor, the first issue raised by Mr. McDonald is whether the Commonwealth's evidence was sufficient on the assault and battery dangerous weapon charge causing serious bodily injury. And I would suggest that that question has 3 different components. The first component is whether the Commonwealth's evidence was sufficient to prove a permanent disfigurement, that specific serious bodily injury. And I would also like to point out to the court that the only allegation here on the permanent disfigurement was chipped teeth. I would like to point out to the court that as the Commonwealth cites in its brief or in their issues presented, it was not broken teeth. These were chipped teeth. But in any regard,
Let me back you up for a minute. So is it your position that chipped teeth is not sufficient? Setting aside whether or not that there was sufficient proof of the chipped teeth, because of course you also argued that the jury didn't see any photos, and you also argued that there was no other evidence of it other than the testimony itself. But are you saying that chipped teeth per se?
I'm not saying that. I didn't find a case where it said chipped teeth would be considered a permanent disfigurement, but I could see a court finding that chipped teeth could be a permanent disfigurement.
Okay.
The problem here is we didn't have any evidence of it other than the victims, and I'll use the word victim since the case is partially impounded, of the chipped teeth. And that's the problem here.
And what's wrong with that? What case says you have to have more than the victim's testimony?
So there's no case out there that says that a victim's testimony alone is sufficient to prove a permanent disfigurement. In the cases I cite, in the Anoa case, there's medical records plus, a victim's testimony. Hayward, the same thing. And I think the only case that gets us close in which the Commonwealth cites is the Sigmund case. But when you take a look at the
Going a little
briefs-
bit too fast for me. Which case are you referring
Sigmund
to?
case that's cited by the Commonwealth in their brief.
That's a Rule 23.
It is. And the problem with that case, if you look at the briefs, and I would suggest this court could take judicial notice of the appellant's brief in that case, it seems to acknowledge that there was some injury to the teeth. In other words, it wasn't contested that there was injury to the teeth there. So that really
Was it
wasn't.
contested here?
Here, there was a motion for required finding on the sufficiency of the evidence on chipped teeth, and there were questions regarding the chipped teeth. The problem we have is there's no evidence of chipped teeth. There's no medical records or dental records prior to, and there's no records afterwards. And I would also further suggest that the victim's testimony that she had a lot of broken glass in her mouth, I could arguably see that might resemble chipped teeth. So the only evidence we have is this broken glass in her mouth.
Well, she was pretty clear that the one big chip in the back, and that there was other chips later on, and they were according to her, documented or observed by a dental visit afterwards, right?
Afterwards, right. And we don't have any records of that. In fact, the records.
I'm going back to my first question to you then,
Sure.
which is you have testimony from, and yes, we'll call it the victim, testimony from the victim that my teeth were chipped. And if I understand your position, that is, that testimony alone is insufficient for the Commonwealth to meet its burden.
Correct. And I think the cases support that. The Anoa case, the Hayward case, and the Frederick case.
Well, I guess my point is there's a difference between the evidence being thin and being insufficient, right?
Correct.
So,
And I would suggest it's insufficient here because all we have is the victim's testimony with zero corroboration. Not that it has to be fully corroborated, but something. I think the Commonwealth's burden was to present some evidence here, or at least display these teeth to the jury. She testified at trial, show it to the jury. It wouldn't have been that difficult, but here the Commonwealth didn't do that. I mean, there's other cases that suggest, where there's a scar or some other injury, the Commonwealth asks the victim to display that injury to the jury. The Commonwealth just failed to do that here. And I would suggest it failed to present sufficient evidence of the chipped teeth. And I would suggest there's not a case there that says the victim's testimony alone. And, the Commonwealth talks about some cases that talk about concealment. This isn't a concealment type of case. This is, the Commonwealth had the ability to show the chipped teeth, and they failed to do it.
What about the jaw injury?
So the jaw injury is the second type of way they could show, serious bodily injury. And here, the problem is we have a victim with a pre-existing structural condition, plus habits, documented history of habits that would contribute arguably to that condition. And so now you have these medical records full of terminology, medical and dental terminology that would not be in the realm of a common, reasonable juror to understand.
Well, what are you referring to? Because if you look at, for example, the notes with respect to the arch orthodontist, it's pretty clear what's going on. It's
clear that she has this type of structural abnormality, that she has some sort of TMJ, but it's also clear, and the records also show, that it's pre-existing. There's no delineation.
The doctor does say it's worse. The patient has reported it has worsened.
Correct. And then there's also a report that she contradicts the pain later, that she at one visit, she says the pains, I still have pain, but the note says it contradicts her earlier statements to them. You also have the problem of she doesn't go and see a doctor for months after this incident. And so what you have is technical terms in these medical records, which, some of them I really don't know what they mean without looking them up. In her
that part of your brief
diagnosis.
was pretty amusing, actually, when you went through it. It's definitely incomprehensible. But you're again on this one. You're not saying that such an injury would be, if proven, would be sufficient to be a substantial bodily injury. You're saying that it was not. The causation wasn't proven.
What I'm saying is the Commonwealth was required under their burden of proof to present the evidence. If we look at the Scott case, I think is the best case for guidance here. It tells us that when we have records that are full or replete with terminology that's not easily understood, and I would suggest these records are replete with those types of, I can't even pronounce some of the words. So when we have terminology that's not commonly understood, you need an expert. Or maybe, like in the case that I cited, it's a unpublished decision, the ARCE case, ARCE, that case talks about where the records clearly delineate between a pre-existing condition and the condition, similar back injury, but delineate between the condition post-accident.
Would you agree that the victim's testimony here was sufficient to establish the fact that, yes, she had a pre-existing condition, but it was much worsened by the result of the accident?
I don't, Your Honor, and the reason I don't is because that testimony, while she may have suffered a traumatic event, and there's no question that she did, I think the problem is that testimony gets you to pain, but pain, in the Scott case, it talks about this. She can testify as to her pain and her condition pre and post, but without any corroboration in form of an expert or medical records to support it. You have her testimony, but you really don't have the causation, if you will. And the Commonwealth's cases talk about causation. I suggest you don't get there. You cannot get there without, there is no chain of events without an expert or some medical records to separate pre and post accident. There's evidence here, not only just her pre-existing structural condition, her habits that she's engaged in prior to this, her wisdom teeth being taken out, and it's not clear from these records when these wisdom teeth were taken out. And the records show she has a lot more pain after these wisdom teeth are taken out.
So,
we don't
so
know
your
when.
position is if there's a pre-existing injury, you need expert testimony to show that the incident caused something other than the pre-existing injury.
To show that the actual accident caused the serious bodily injury for which this enhanced penalty is called for. So, and I agree with you there. So the problem is we don't have that. We have these records afterwards, but we also have a pre-existing condition, and it's not really shown from these records which came first, and we don't know whether these surgeries she would have had afterwards, or these pain that was that from the wisdom teeth? Was it from the accident? We really don't know from these records.
You don't know from the records, but you do know from her testimony that the pain significantly increased after the accident. Also, in addition, that her migraines, which she had suffered from beforehand, had also significantly increased afterwards. But you're saying that's not enough. You're saying that the Commonwealth, at this given that situation, the Commonwealth had to have expert testimony. So what is your point?
The Commonwealth probably could have shown this through, maybe medical records or dental records prior plus post. They didn't do that. They had an opportunity and they didn't. They could, and I think Scott is pretty clear. Where we have terminology that's necessitating of an expert to explain the terminology, explain the difference between the pre-existing condition and afters. I think the cases the Commonwealth cites too, the Scafuri case and the Hayward case, there's no evidence in those cases of a pre-existing condition. The only case that they cite to where there is a pre-existing condition is the Baker case, and in that case, the medical examiner testified that the pre-existing condition had nothing to do with the death. So I think the problem here is not just that she had a pre-existing condition, it's also terminology that goes unexplained. So the jury's left with these medical records unguided. And the victim can make can testify as to what she felt afterwards, but she cannot testify to the diagnosis, and she cannot
testify to what, excuse me?
Cannot testify. She made some testimony about how, she never had this accident, this wouldn't have been a problem. But under the Scott case, she's not able to make that type of testimony. It has to come from an expert to show without this accident it wouldn't have been a problem. And I don't think you can get there from these records.
I think we understand your point on that issue. Yes, your time is short, so I don't know.
I had a question, a legal question on it.
Okay, go ahead.
The Commonwealth says that we only have to find sufficient evidence of one of the two under ANOA. What is your take on ANOA?
So the problem with ANOA is, in that case, there was one injury, and there were three definitions of serious bodily injury. So in ANOA, the injury just had to fit into one of those three definitions. Here, the Commonwealth presents the serious bodily injury, but two distinct injuries, permanent disfigurement and substantial, the TMJ. So there's two distinct injuries, there's two distinct theories of guilt, but they present a general verdict slip. So the problem is, if this court should find that the evidence was sufficient as to one of those but not the other, then Mr. McDonald is entitled to a new trial because the jury slip wouldn't allow us to determine which theory of guilt they found was sufficient. And the Commonwealth does not address that in their brief, but I think that's a significant issue. Thank you. With regard to the second issue, Mr. McDonald's constitutional right to proceed pro se, I would suggest that the cases here are older cases. They're from the 90s. And they talk about what's required of a trial judge to determine whether a defendant has waived his right to counsel and asserted his right to proceed pro se. And I think here the suggestion is that the conversation that the judge engaged with Mr. McDonald was just not enough. It wasn't really a meaningful inquiry.
Those cases, I'm sorry, counsel, those cases involve when there is a request for self-representation. The judge has to proceed with this detailed colloquy to determine that the defendant fully understands that he or she is waiving the right to counsel. And so it's a very important inquiry to make sure that the defendant's aware of the decision. But here the problem is that there didn't seem to be an unequivocal request to proceed through self-representation, but rather just sort of, I think the defense, what about going pro se? I have the right to go pro se, don't I? Right? That wasn't much of a request, as sort of a comment.
So right, when he asked to be heard and the judge heard him, and I think what should have been done here is the judge should have taken a step back and said, well, let me talk to you about that. You want to assert your right to self-representation. Do you understand what that means? The judge didn't do that here. He said, I think you need, you're facing a first-degree murder charge. I think you need competent counsel. He kind of, inserted his own judgment, as opposed to Mr. McDonald's. What he should have done is taken a step back, and said, okay, you realize you're asserting your right to proceed pro se. Do you understand what that means? Kind of like almost in a colloquy on waiving a right to a jury trial. You know, it would be helpful to a judge, if the judge had said, you realize you have a constitutional right for representation or to represent yourself. You realize you're waiving your right to counsel. You realize you're asserting your right to self-representation. And then go from there. But that just simply wasn't done here.
It seemed like you think the judge had an obligation to kind of draw out the request, to actually make the defendant make a formal request when he hadn't, right? I mean, that's the problem, right? The defendant sort of says, what about going pro se? And the judge just kind of moves on, essentially, you know. But you're saying the judge had an obligation at the point to sort of say, oh, what you're really doing now is you're making a request to proceed pro se. Let's talk about that, right? Which seems a little bit presumptuous of the judge to kind of jump in and tell the defendant what he's doing.
I think particularly in this case, we're not talking about on the day of trial. We're 2 weeks before trial. There's no rush as far as kind of fleshing this out. It's not the morning where we've impaneled a jury, which the cases talk about. There's no jury impanelment yet. There's time to go through this. And the judge could have taken a step back and said, okay, what are we talking about here? He didn't do that. And I think that the cases suggest that he really has to engage in this kind of conversation with someone asserting a constitutional right to self-representation.
I know your time is up, but I actually have a housekeeping question, and that is, am I correct that this issue was not raised again during trial? Did I not? I want to make sure I didn't miss something.
I do not recall from the transcript
I
that it
didn't
was
see
raised
anything
again.
again, but I
can
assume
go
that you would have alerted us to that was the case. Let me check with the panel, see if there's any additional questions.
That was my question. I just want real quick. You cite the 1991 cases you're talking about as it's a First Circuit case about this three-part inquiry. Is there a Massachusetts analog?
That relies on the Tuitt case, which is a Massachusetts case, and that is the Tuitt case, which is also cited in that Betancourt case, as well as Commonwealth cites to that case as well. That is a Massachusetts case.
Thank you.
I just want to note that you didn't get to your last point, which had to do with the sentencing, but you can rest on your brief on that and be assured that nothing's waived.
Thank you, Your Honor.
Okay, thank you.
Thank you.
Thank you.
Good morning. May it please the court, Stephen Nato on behalf of the Commonwealth. I'd like to acknowledge before I begin, one of the trial prosecutors, ADA Courtney Cahill, is present in the courtroom with some victims as well as relatives of Julie Mead, as well as our advocate, Lori Burke. And just on that note, to be clear from the record, the other prosecutor was Stephen Nato Sr. I'm Stephen Nato Jr., just so there's no confusion.
Any relation?
But to begin with the first issue where my sister began, under the Lattimore standard, the evidence here was sufficient as to both theories raised in the briefs, both the permanent disfigurement and the impairment of a bodily function. So regardless of the wrinkle she highlighted in the ANOA thing, whether there has to be a special verdict slip for under both theories.
Well, no, not a special verdict slip. I mean, there's and maybe not even specific unanimity, because the jury could. I think the rule would be that if 6 jurors thought chipped teeth and 6 jurors thought TMJ, that would be okay. But wouldn't there have to be sufficient evidence of both?
I agree with Your Honor, but I would say there's no issue there because there is sufficient evidence of both. Again, she testified to the chipped teeth. Certainly, it's an unpublished decision, but Andrews recognizes that the victim's testimony can suffice to establish that kind of injury. It doesn't need to be displayed to the jury. Furthermore, the Beal, Scott, and Noah cases talk about jurors being able to consider through their own common sense the nature of the injury, the circumstances in which it was caused, and certainly here, the kind of very serious car accident. Fortunately, she was lucky she only got chipped teeth, but nonetheless, that qualifies as a permanent disfigurement, whether or not they were repaired within the 5 years plus preceding the incident and trial in this matter. Furthermore, as to the jaw injury, regardless of the condition of her jaw prior to the incident, her testimony was very clear that kind of her life changed after that accident as a result of this injury, multiple surgeries that include detaching the jaw, pulling it forward, and debilitating headaches that had a significant impact on her work and personal life. And she said that this didn't happen to me prior to this. The jury could, again, based on their common sense, based on the nature of these circumstances here, infer that indeed it was this very serious car accident that caused that injury and led to these effects. And certainly under the Lattimore standard, we're entitled to that result. If there are no questions on...
Well, just what's your response to their argument that, you know, just the complexity of the pre-existing condition, there would need to be some kind of expert evidence to distinguish between the cause from the car accident and the there need to be some additional evidence to kind of separate those issues. What's your response to that?
Well, I think that although there are some technical terms that perhaps the ordinary jury would not be able to themselves understand in the medical records, there are nonetheless easily understandable descriptions in there that any jury could look at and would be and corroborate her testimony. But I think her testimony is enough as to the change she experienced, again, regardless of whether she had the occasional clicking in the jaw. She described certainly the medical records of the increase in migraines and headaches and pain and that kind of thing, and the surgeries that she underwent. So that was sufficient.
And you also think, I'm assuming then your position would also be that there was no need to have anyone interpret certain terms and the various diagnoses that are contained within the medical reports.
I'm sorry, can you repeat that?
I'm assuming that you were also saying that there was no need for expert testimony to
Correct.
explain the technical terms and the various diagnoses that she had.
And given the balance of what was sort of understandable to a layperson in the record.
So did you understand all those medical records?
Not all of them.
I didn't think so. They were a little complicated.
Yes, some of them, but I think, again, the balance of what is clear to a layperson, to myself, based on the records, the jury could have used that, and it corroborates her testimony. Turning to the second issue, I suggest the defense argument regarding the motions, as he calls it, to proceed pro se, was properly denied. The motion was neither unequivocal nor timely, coming as it did in the context of a motion to appoint new counsel, which, as the defendant indicated in the hearing, new lawyers need more time to get up to speed.
And he wasn't trying to replace counsel. He wanted an extra counsel, right?
I'm sorry?
He wasn't trying to replace current counsel. He wanted another lawyer.
Right. Right. So again, it's sort of, but it's clear he wants to be represented. And then sort of as the judge, again, after 5 years plus, 2 weeks before a fairly complicated trial is about to begin with a fairly complicated defense, as the judge is essentially about to get off the bench, it's, well, what if I'm not there at all? What if I'm pro se? What if I have standby counsel? That is not, certainly not timely, but it is not unequivocal. And so the finding that even if he was raising it, this was a purely dilatory tactic, was well supported by the record. There are no other good reasons.
Well, I take your point on that, but defendants do have a right to proceed with self-representation if they want to. And this may well not have been kind of unequivocal requests that's necessary to sort of invoke that right. But the judge did seem kind of to shut it down by saying, well, this is a first-degree murder charge. You're allowed to represent yourself even in a first-degree murder charge, right? So I guess the question is, what kind of statement is necessary by the defendant to get the judge to sort of start with the inquiry that's required to ascertain whether self-representation is appropriate?
I think it would have taken something unequivocal. And here, there was time for that. The judge did not foreclose it, totally said that is your right, but I think you should have a lawyer go off the bench, and then in the interim between this hearing and the trial, issued his findings. This was not a request to pro se, so certainly by that point, the defendant was on notice that if I want to assert my pro se right, I must do it again. But then I think...
Even though the judge says that such a request would be untimely, and that's what the judge says, the court noted that such a request would be untimely.
I think that's true, but if this were something the defendant was truly wanted to assert, he had the opportunity to do so again.
And you know the record well, I presume, and the issue was not raised again during trial, correct?
No. I don't, unless I missed it, but no, I don't believe so. If there are no questions on that issue, I will turn to the sentence. The sentence here, the appeal to the sentencing division was dismissed. So unless...
Is that term dismissed, does that mean it was heard and denied, or did not get heard?
My understanding is that it's essentially the rejection. The record does not make that clear to me. But even proceeding to the merits, the defendant has not identified an error of constitutional dimension or an illegal sentence. All of these sentences imposed were within the maximum under each statute.
Well, I think the defendant's point here is that what was on the judge's mind was the murder charge, not the voluntary manslaughter charge. And I think the argument here is that, and that's, of course, I was acquitted of that, and so I shouldn't have gotten the maximum for the voluntary manslaughter.
Well, I think what was on the judge's mind was not the murder charge, but the facts and circumstances of the case, which was a brutal manslaughter in front of the victim's young children that was then carried out onto the highway. Regardless of how that charge is categorized, it is a severe, brutal incident that, again, within the judge's discretion, he could sentence up to the maximum. It is within his discretion to set consecutive sentences. As he said, there are 3 victims named in these indictments, and this sentence is for them. And so showing that he's focused on, what's in front of him, not kind of looking beyond what took place at trial. Again, not an illegal sentence, no error of constitutional dimension. The sentence I respectfully suggest should stand.
Can you shed any light on the fact of why the sentencing occurred immediately after the jury returned its verdict?
I'm sorry?
Can you shed any light on why the sentencing occurred, as far as I could tell, immediately after the verdict was returned? There was a comment that the jury was still there. I presume that the jury had been excused and maybe was sitting in the courtroom.
I'm not sure. Usually there, would be a break. Sometimes the jury is usually welcomed back in for sentencing. Sometimes, depending on the nature of the case, obviously a sentencing date is continued. I'm not sure exactly why.
It happened that way in this case?
Right.
Okay.
But I don't think there's any impropriety in it that I'm
not making, I'm just,
Where,
I'm not, you should not read anything into my question. I'm just asking, it's unusual.
yes.
And in fact, the defense counsel asked about sentencing guidelines. I mean, the situation went rather quickly. I don't know if it had to do with, the case was old and apparently all the victims were in the courtroom because they were prepared to give their victim impact statements.
I know, obviously they did give some impact statements that may have played part of a role in it. Again, I'm not sure, not disclosed by the record, and
Okay.
did not think to ask prior to the argument. If there are no other questions,
Questions? I see no further questions. So
Thank you.
thank you all for coming today. We appreciate your making the trip. We know it's not easy to come here and hear about the case. So thank you very much for being here, and thank you for your arguments to take the case under advisement. All right. You doing okay to go on to the next case? Okay to go on to the next case? So do we have numbers? Okay, I got a little confused. Case 3, they're not here? Oh. Mr. Trundy? That arrived. Okay, so we'll wait we'll do that. So we'll listen to case number 4. Perfect. All right. We have a little change in our schedule this morning. So we're going to hear the case that's scheduled to be heard 4th, now heard 3rd. And that case is NAHANT Preservation Trust and others versus Northeastern University, 2023-0482. And before we start, I want to be sure that I understand who is arguing and for how long. So we have two lawyers representing the appellants, correct?
That's correct, Your Honor.
All right, and are you Mr. Clark?
I'm Mr. Harley Racer, Attorney Harley Racer for NAHANT Preservation Trust.
I'm sorry, are you correct that that's how you're here, but I looked at your middle name instead, I apologize. Okay, and you were going to take 10 minutes?
That's correct, Your Honor.
All right, and Attorney Pucci is here as well? Okay, and you're going to take 5? All right. Okay, so we're ready to go.
All right. May it please the Court, Harley Racer for NAHANT Preservation Trust and 27 citizens of NAHANT. Why did Northeastern University grant the public...
You can bend it up.
Why did Northeastern University grant the public unfettered access and use of the northeast portion of its property for 52 years as a public park, including for walking, hiking, bird watching,
Could you back up a little bit?
fishing? Yes.
You just called it a public park, and you also said unfettered access, right? So did the public have unfettered access to the entire 8-point-something acre area?
Well, the portion that Northeastern owns is they own approximately 20 acres of the 28-acre peninsula, with
Okay.
the town of Nahant owning Lodge Park, which is the 8-acre
All right.
portion.
Thank you for that.
And the public did have unfettered access to the portion, the northeast portion of Northeastern's property that's about 12 acres and referred to by Northeastern as the Wildlife Preserve. It's contiguous with Lodge Park. There's pathways that connect from Lodge Park to the Wildlife Preserve, and the public did have unfettered access for 50 years to that area.
So do you contend that it was a dedication to be a public park or a wildlife preserve or some combination of the two? What's your position on what the dedication actually was for?
Correct. The public dedication, it was a dedication for public use as a public park for open space, wildlife habitat, and for passive recreation. And there's ample evidence that it was intended to, from the beginning, be preserved as a wildlife preserve and to protect the open space and the natural beauty. And it was also used as a public park with passive recreation uses that are entirely consistent with
But a wildlife preserve and a park with unfettered public access seem to be two fundamentally different things, right? If you want to protect wildlife, you don't allow everyone just to walk around and hike and do what they want, right? So I'm trying to understand, isn't there some tension between these two purported purposes of the dedication that you claim?
I don't think so, Your Honor. I think that you have a wildlife preserve that is it's protected as an ecological habitat, and the public is allowed and welcome to enter the habitat to observe the wildlife. They observe the wildlife from afar. They observe the wildlife in the habitat. But it's also the rejuvenated ecosystem and protection of the natural view is the purpose of this park. And they're all parkland purposes that are proper dedicatory purposes for the public. So, but the question is, why did Northeastern allow this access, and why did Northeastern preserve it this way? Was it because they intended to dedicate it for public use, or was it for some other reason? And to determine their intent, under Hayden versus Stone, Smith versus Westfield, and the recently decided Carroll versus the town of Norwell, no formality or writing is required for a public dedication. An intent can be established through oral assurances and a course of conduct. And as Hayden and Smith tell us, the best evidence, the strongest evidence of the property owner's intent is how the property was actually used. And if it was used by the public, that's strong evidence that there was an intent to dedicate the property for the public use.
And can that public just be the limited residents of Nahant, or does that public have to include the general public?
Well, once property is dedicated to the public and accepted by...
Oh, you said that excuse me, I want to be more specific. When you talk about the prior use, right, and you're saying that the use of these residents of Nahant, of the area for the passive recreation, et cetera, that is enough to show an intent to dedicate this land to the public. But doesn't it need to also be more open than that. It had to open to the general public in order to establish that intent.
Well, it was open to the general public, and the use by NAHANTers, and there's facts in the record that it was used by people outside of NAHANT, in addition to NAHANTers. That use is sufficient to form an acceptance. The intent to dedicate it for the public is to the general public, and the use can be shown by a representative class of the public, including NAHANTers, and including the town of Nahant. But there's also facts in the record that there was use by people outside of Nahant.
Weren't there facts in the record, too, that Northeastern had a security guard and didn't allow people in and discouraged even Northeastern people from coming?
There is some evidence there's two internal memos, one of hiring a caretaker, but this was in 1965, and the reasonable inference on summary judgment in our favor is that this caretaker was hired to protect the facility, the Edwards, what became the Edwards Marine Science Center. There's no suggestion that he was securing the property, the northeast portion of the property that is the wildlife preserve. There's also an internal memo that discusses the Northeastern staff not going to Lodge Park, what became Lodge Park. At the time, it was still reserved by the Navy, and there were these Nike missile silos there. It was a black paved top, and they were worried about security and safety there. But with those reasons, and there's evidence of one no trespassing sign. There's no evidence as to where that no trespassing sign was, when it was put up, for how long. But there is testimony from through the interrogatories and affidavits that the public never saw no trespassing signs, and there was no restriction on the use and the access. Because the public dedication that we are talking about is the wildlife preserve, and there are certainly other portions of Northeastern's property that they may have secured, such as the Edwards Lab and parts other than the wildlife preserve.
Counsel, sorry, were you going to ask?
No, I was just going to ask to what extent the proposed buildings impact on that area that you say has been publicly dedicated to.
It would destroy it completely. We're talking about a 12-acre site that has been allowed to rejuvenate and mature over 50 years. Migratory birds rely on this. Over 180 species of birds have been identified in this area. They would clear-cut the trees. They would remove 10 feet of soil off of the Murphy Battery. They would clear what's referred to by them as the thriving meadow. And so the entire wildlife sanctuary, the thriving meadow, would be gone. It would be replaced with a 55,000 square foot building and a geothermal well field. They've said that they would landscape it afterwards, but that's not the same as what is there now. As I said, 180 birds, including threatened and endangered species, have been observed there. And the reason that...
So is the point that there's no remaining portion of the wildlife preserve that could be enjoyed by the public?
Absolutely. That's absolutely correct. There would be nothing left of the wildlife preserve. That's what would be gone. And the significance of 180 bird species is not because birds have standing, but it shows that the public has used this. Those were observed by birders. People make treks there. They go and do bird counts from all over the state. This is a vibrant habitat, and it has, to Northeastern's credit, they have created an ecological sanctuary, a wildlife sanctuary at the tip of this peninsula. It's the largest undeveloped headway south of Cape Ann. It sticks 2 miles out into the ocean. It's a 20-acre peninsula that's completely undeveloped and contiguous with the town's Lodge Park. But
even if we concluded that there was a disputed issue of material fact with respect to the public acceptance prong, don't you also need to establish a disputed issue with respect to the public dedication prong in order for us to reverse the court's grant of summary judgment?
I think that gets to the key of the court's error. The trial court failed to consider the public's use of 50 years.
Can you answer the question? Say you win on public use, don't you also have to establish that there's a disputed issue as to public dedication? There has to be a clear and unequivocal intent established as a dedication, right? You have to win on both those prongs.
We have to win on both those prongs, but at this stage, we just have to show that a rational jury could find that on both prongs. And the best evidence of Northeastern's intent to dedicate is the public's use for 50 years. That's what Smith tells us.
That argument just kind of does away with the dedication prong by saying, well, use is enough to establish a public dedication. Right? Don't we have to look at the 1965 documents and sort of discern from there the clear, unequivocal intent?
you can discern I respectfully disagree that it does away with it, because what you look at is you have the strong, best evidence of the public's use, and then you see if there is any countervailing evidence that refutes and negates that. And if you look at the 1965 documents in the historical context, they're all consistent with assurances made by Northeastern. You can see Northeastern's intent. They assured the public that they would preserve the natural beauty, and they assured the public that they would work with them to provide access to it.
They assured the public, as I can see it, only that they would provide a walkway around, correct?
They assured that they would work with the town in every way so that the public would get the benefit of the natural beauty.
Well, what evidence do you have that the town even wanted this at that time? Because
In the 1965 town meeting, in 1964 town meeting, the town decided that they could not allocate the funds to purchase it and clean it up and then maintain it. But they formed an advisory committee to chart East Point's future. And chaired by Ruth Alexander, and she made every effort to find a steward to the land, and they reached out and found Northeastern because Northeastern would preserve the land, and that's why they gave support to Northeastern's acquisition to the federal government. The town relied on those assurances, the federal government relied on those assurances when it granted Northeastern the property at a 100% public benefit allowance, and Northeastern...
And you're taking that from what? The fact that the federal government actually decided to give the land to Northeastern? That's the only evidence of that intent.
Well, there's more evidence than that. We have a letter from Ruth Alexander in April to the federal government saying that they would support Northeastern's acquisition because they're going to preserve the property.
No, you said that the federal government intended
And the federal
something.
government responded 4 days later that if Northeastern applies, they'll consider the public benefit. And then Northeastern wrote to the federal government and said, we've had this meeting with the town and gave them these assurances, and the federal government awarded it, and in a letter said it's a 100% public benefit allowance. And I can tell you where in the record that is if you want to know.
No, that's okay. We'll
Okay.
definitely find it. But your time is up, and I don't know if there's other questions for you from...
I have one more question.
Sure,
Maybe
go
it's a
ahead.
good question for the town, but there seems to be a big difference between what the town originally wanted, which was a walkway for town residents, not for folks from Boston, Somerville, and Chelsea, to view the ocean and the cliffs, a walkway, right? It seems very different from what you're claiming actually happened, was this kind of general all-purpose public use that you allege occurred over the last 50 years, right? So can you just address that gap between the specific walkway request that was never really acted on and what you say actually happened over the last 50 years?
So, absolutely. The discussion was from the beginning. There's assurance was made that Northeastern wouldn't develop the property. It's going to be open space and it's going to be preserved. The second component that the town was looking for was some kind of access. And the record shows several discussions about what form that access would take. There was discussion about an easement, about a walkway. There was some discussion about permits, irrevocable licenses. We don't see any formalities of what was actually, nothing was reduced to writing as far as we know. But what we do know is that the public was granted access to appreciate and use this natural beauty because it happened. And Northeastern never developed on the property.
But the walkway never did happen.
The walkway never did happen. If there are no further questions, I'll rest on my brief. Sorry. Thank you, Your Honor.
Thank you very much. Okay.
Ready for me? Good morning, Your Honors. May it please the Court, I'm George Pucci, and I represent the town of Nahant. I'm going to start with my 5 minutes of fame here in follow-up to those last questions, because they're relevant really to both the dedication claim, which the town relies on, everything that the Preservation Trust is arguing on that, but the relation or the kind of intermingling between that claim and the estoppel claim that the town has asserted. You know, this is part of one transaction at the beginning. So in 1965, there were two key representations made by Northeastern. One is in the proposal directly to the federal government, April of 1965. The university seeks to acquire the whole of East Point in order to make it a wildlife preserve. And Northeastern focuses on the fact that wildlife referred to benthic organisms, you know, organisms related to the sea. And that's all well and good, but the fact is, a wildlife preserve was supposed to have been.
There was also some more than that. Northeastern also said that there were additional facilities would be constructed by the university, initially will include the pump house, storage tank, quarters for a caretaker, et cetera.
Correct. In relation to the existing use, no type of contemplation of a enormous building that, is being proposed now. And so the point is, though, whatever the reason Northeastern represented that they would have a wildlife preserve, whatever organisms they were interested in, the fact is they promised a wildlife preserve to the federal government. And Northeastern focuses on the fact, well, this is a representation made to the federal government, it's not even to the town, so how can the town rely on that? Well, in immediate proximity to that, in May of 1965, the president of Northeastern wrote to the federal government again, and he summarized a meeting that he had had with the NAHANT Select Board, Advisory Committee, all of the decision-making personnel of the town, and he said, as a result of that discussion, again, in proximity to this representation within the same month that it would be preserved as a wildlife preserve, that there was overwhelming support from the town for Northeastern's acquisition of the property. The reason that's important, and in other words, this goes to the estoppel claim. The town is relying, and what they're doing in response to the representation is they're supporting Northeastern's acquisition of the property from the federal government. So that's an act that they're doing in reliance on Northeastern's representation, and it's documented right in the evidence. And again, reasonable inferences have to be drawn in favor of the party opposing summary judgment. And to Your Honor's question, something that with my limited time that I really wanted to focus on about the town's actions in the case and the history. So Northeastern gets the initial parcel on East Point. Then when the contiguous 8 acres, which the town now has for Lodge Park, when that came up, that the federal government also wanted to transfer that, Northeastern wanted that parcel as well. And at that time, the town then competed with Northeastern that, well, they're maintaining the wildlife preserve, they've got open space, we need this for open space purposes, we're going to now ask to acquire that parcel, the 8 acres. Right. And this goes both to Northeastern's promise about the wildlife preserve and also the town's good faith efforts in this matter.
Your point is the town would not have taken on the responsibility of those 8 acres if they had known that the wildlife preserve was not going to always be there, is your point, right?
That's exactly right. And when we're looking at equities, I wanted to focus on this part of it. The town has been in good faith right from the beginning on this matter. Yes, they supported Northeastern's acquisition of the initial parcel. Then they, based on Northeastern's use of that parcel, wanted to acquire the 8 acres for open space purposes. And in that documentation, when they applied to the federal government, and the federal government chose the town over Northeastern at that point, saying that the town wants it as open space, Northeastern's parcel has the wildlife preserve, the town has represented that they're going to work in every way possible with Northeastern to anything Northeastern needed for their educational purposes, the town would cooperate, and the town was also paying fair market value. And at that point, the town had pointed out to the government, the federal government had taken 50 acres of NAHANT in connection with military uses. Yeah. NAHANT is only 1 square mile. It's basically the smallest community in the Commonwealth by land area. They had also given up to the MDC the causeway area. So they were at that point focused on open space, and that's why they acquired this 8-acre parcel in reliance on the wildlife preserve as a whole.
I understand that point, and you've made it well in your brief. You are over your time, so I just want to see if there's any specific questions that the panel may have of you.
I want to understand the geography, and I think I've got this. The Lodge Park is sort of coastal, right? And they're proposing to build sort of behind it. Is that?
Well, no, where they're built, right. You pass through the Northeastern parcel, and the town has easement rights over it, to that parcel that's seaward of Northeastern's parcel. So where they're building, so when you're up on that elevated site, Lodge Park, you look right at the wildlife preserve, and that's where they're seeking.
You turn your back to the ocean.
No, when you're looking toward NAHANT, when you're looking toward the land, you will see the building from East Point. If you're looking at the ocean from the other side of Northeastern's parcel, you will see the giant building instead of the ocean. See what I'm saying? In other words, the NAHANT piece is this, Northeastern's is this. Here's the ocean.
Okay, right.
And it surrounds it like a peninsula.
That's, okay, thank you.
Is there a proposed site plan in the record? Yeah,
Oh, yes.
okay.
I wouldn't hazard to guess where it is, but there is. There's also a very interesting site plan related to development of Lodge Park for passive recreation, which is another key part
That
of
one
the
I'm
town's
familiar
reliance.
with. All right, okay.
Thank you, Your Honor.
Thank you very much.
Good morning, Your Honors. May it please the Court, my name's Kevin O'Flaherty. With me is John White, and we represent Northeastern. Justice Toone, you put your finger right on it. There has to be a dedication by Northeastern that manifests clearly and unequivocally its intent permanently to surrender its rights to use and develop over half of its property. This is what they claim happened in 1965. It didn't, and their own documents show that. The words of the town in several documents show that no such dedication occurred. There was no reliance. There was no unequivocal, clear, manifested statement or act by Northeastern that does anything close to a dedication.
Well, what's your response to the trust argument that under Hayden v. Stone, evidence of public use is, quote, very strong evidence to show an intention to dedicate?
Where I think that that case stands for the proposition, and Hayden v. Stone also says mere user does not a dedication make. But Hayden v. Stone, as well as some of the other cases they cite in their documents, in their brief, stand for the proposition that where the intent of the dedicator is shrouded in obscurity, one of the cases says, where that intent at the time of the alleged dedication cannot be ascertained. A fella has a piece of property, he builds a road, he dies. This is what happened in one of the cases they cite, Baker v. Peace, which is a Texas case. But this guy builds a road across his property, he dies. The public starts to use it openly and notoriously for decades, but nobody knows what was in the guy's mind when he built it, whether he wanted the public to use it or not. In a case like that, then the court looked at, well, what happened after that? Did the public maintain it? Did the public improve it? Did the public do anything to exert control over it? And in those cases, they did. Hayden v. Stone is a similar case. It's a road case where somebody built a road and then the public started using it, and the question was, well, was this a publicly dedicated road at the outset? We don't have any question about Northeastern's intent here. At the origin, let me read you what Ms. Alexander, who Mr. Racer quoted a few times, what she said in 1965 in the town annual report. Got to put my glasses on for this. Paramount among the activities. This is in December 1965. By the way, December 1965 is several months after the two smoking gun documents they allege that Northeastern used to make a dedication. Those documents were from April 65 and May 65. But in December 65, in the town's annual report to its citizens about what's going on out at East Point, they say, paramount among the activities of the commission during this year were the encouragement of Northeastern University to become interested in the government property at East Point. The town chased Northeastern on this. Northeastern didn't come to the town and say, please support us in our quest to start a science center here. The town chased Northeastern, and I'll tell you in a minute why they did, because that's also in the town's documents. But it goes on. An attempt by the commission to secure for the townspeople only, as Your Honor noted, or one of Your Honors noted.
It was not the general public, just the citizens of Nahant.
Right, to walk around the cliffs of the property. At the time of the preparation of this report, again, after the two smoking gun documents allegedly created a dedication, it seems reasonably certain that Northeastern will acquire the East Point property for the purpose Now, here we go. Are they going to say for a wildlife preserve? No, for the purpose of a marine biological study, not for a public wildlife preserve. They don't say that. The commission was not able to secure from the government and Northeastern assurance, no assurance, that there would be an absolute right on the part of the townspeople to walk on a pathway around the cliffs. The commission does hope, however, that some form of visiting privilege might be extended by Northeastern. Later, Miss Alexander, same Miss Alexander, was the head of the CONCOM. She was also part of the subcommittee that chased Northeastern to get them interested in the property. And why did they chase Northeastern? Because, Your Honors, in the record is the answer. They chased Northeastern because at the time, the government had come to the town and said, we'll sell you this 28 acres, but you got to use it for a public park open to everyone from Boston, Somerville, Chelsea. The town said, we don't want that. Miss Alexander said that you can read it in the town meeting minutes of 1964, which is in the record. She said, we don't want all the place to be open to everyone. We want it just for ourselves in this little perimeter path. And so they went to Northeastern to, if you will, ride to the rescue and protect them from that, and also protect them from what Charles Kelly, who was the then select board chair, wanted. He wanted to sell those, he wanted to acquire the 28 acres and flip it to private developers. The town wanted neither. Those two possibilities the town rejected. The result of a dedication, as Your Honor pointed out, is that the general public obtains an interest in the property in the nature of an easement. They didn't want that. They specifically didn't want that. They rejected it. They didn't want people from Chelsea, Somerville, and so on coming across the causeway. And
I think to restate their argument in a sense is that, well, Northeastern provided some assurances that there would be access to the property in some form or another. And what was actually granted, in fact, was general public use. It may not have been exactly what the town was trying to get at the time, but close enough to what actually resulted over the last 50 years that we should treat that as a dedication for public access.
I don't, respectfully, Your Honor, I don't think Northeastern promised even sort of periodic or sporadic public use. In fact, as one of Your Honors pointed out, one of the first things Northeastern did after it became the owner of the property was to hire a security guard. And that letter is in the record.
I'm not sure you got your money's worth on with a caretaker based on this record, right? I mean, Your
Honor, you're talking about...
It seems like at least when we have to construe the evidence in the favor of the trust in the town,
sure.
Public had access, public enjoyed access.
Well,
they birded, they hiked, they did all sorts of things.
I would say, I hear you, Your Honor. And Judge Karp did exactly that. I mean, he made the inferences he needed to make in their favor. But it comes back to the critical issue, always. Acceptance can be manifest by certain actions, but you have to have a dedication. You have to have that element satisfied. And we have here, in the evidence I just pointed out to you, evidence that negates the dedication. Doesn't just run against it. It basically explains the town didn't want it. And Ms. Alexander later wrote in a letter, this is at volume 7.
I'm sorry, we're talking about the dedication element.
Yes.
Isn't that in Northeastern's mind as opposed to the town's?
Well, correct, Your Honor, but under Smith and the case we all cite as supplemental authority, Carroll, the test is a totality of the circumstances test. And so while Northeastern's intent is what's at issue, and by the way, contrary to their arguments, intent is something that can be resolved on summary judgment. The SJC just did that in Carroll, the case we all cite as supplemental authority, because it isn't really what was in Northeastern's mind in 1965. The question is, under Smith and the cases, what do the totality of the circumstances manifest? That is, the statements, the writings, the actions, not just of Northeastern, but of everyone involved in this little drama. And what Judge Karp below found properly was that the totality of the circumstances negated the dedication claim, or at least, at the very least, demonstrated that they couldn't show unequivocal, clear manifestation of Northeastern's intent permanently to relinquish its rights in over half the property it hadn't even acquired. So, Your Honor, the thing I was going to say about Ms. Alexander is this. She writes, after what the piece we just read in the town annual report, she writes a letter at page 34 of volume 7 of the appendix, where she says, we hope, and this is to the GSA, we hope that Northeastern will grant us some rights to go around the perimeter of the property, but we know that didn't happen. And the town even, and this is in the record, the town even presented a proposed agreement for Northeastern to look at to that effect for the walking path, and that was never executed. So they didn't get that, and they admit that in the 1965 annual report. And then she says in her letter, we hope for this walking path, and we also hope that Northeastern will agree to only develop the property with low-lying or unobtrusive buildings. In other words, Your Honors, the town knew at the time Northeastern had the absolute right to develop that property and was going to do it, as Judge Vuono, you noted. Northeastern says it over and over again in its writings at the time and throughout history, throughout the 60-year history we're looking at here, that it intended to use and develop the property to its fullest extent. This is in the 1965 proposal. Those words are there. In the 1965 proposal, what was the wildlife preserve Northeastern wanted to create out there? It was to protect the benthonic and littoral, these are words I had to look up, the benthonic and littoral attributes of that site. Where is that? That's at the seashore. Why is that? Why was that interesting to Northeastern? Because that's where a marine science center does its business, at the seashore. In 1965, Your Honors, and there's documentation, quite a bit of it, including pictures, that will demonstrate this. In 1965-66, that 28 acres of this peninsula in NAHANT looked like the dark side of the moon. It had been denuded of all vegetation. It had been heavily, heavily altered by decades of prior heavy military use. It had been excavated, filled, blasted. Buildings had been built. Giant bunkers had been built underground, all a part of the military. And if you look at the pictures of what that place looked like in 1965-66, there wasn't anything on it that was of ecological value or worthy of preservation. If Northeastern had said they wanted to preserve the site as a wildlife preserve, they would have had to create one, because there was nothing there but dirt and old military buildings.
But that's effectively what's happened, right? Northeastern
They let
has
it
created
go. They let natural succession occur. That's
And now
different.
it's fairly a thriving wildlife preserve, both
Well,
in
it's
the littoral area and elsewhere,
it's-
right? I mean,
It's not a wildlife preserve, Your Honor, I would say. I'd say it's an area where there's a lot of invasive species that have grown up over time in the area to the east of the Murphy Bunker. And there are birds and the like, as Mr. Racer said, that do migrate in and out of that area. But those birds don't just land on Northeastern's property in NAHANT. They land on everybody's property as they're migrating. I mean, they don't know. They're not saying, let's take a left here because we always stay at Northeastern.
Mr. Fleury, can I
They're
ask
everywhere.
you nodded that there's a plan, that the proposed plans are in the record somewhere. Could
Say
you,
again,
you
Your
not,
Honor?
you,
Yes.
Could you tell us where?
Yes.
It's a voluminous record.
I need the site plan.
So that's what it looks like if it's all printed out in that binder there?
Yeah, I have it in a tab. It might be, just look at the tab. Mr. Whiter's going to try to fish it out
Okay.
for us, Your Honor.
And, I mean, and there's a little bit of talk about the
We'll get
Dover,
it-
there's a
we'll
little bit of
send- we'll
talk
send
about
it
the
to you.
Dover amendment in the briefs. There's talk about the Dover Amendment in the briefs.
Yeah, just a little bit, yes.
And so is the proposal subject to some sort of zoning restrictions?
Well, let me address that, because one of the things they've argued over time is that the town put a natural resource designation on Northeastern property and some of the other seaside property that's up there in the East Point area. But that natural resource zoning designation doesn't eviscerate the Dover Amendment. And in fact, in the language of the NAHANT zoning bylaw itself, it says religious and educational uses are allowed in this area.
Are there setback restrictions? Are there height restrictions?
Sure, there are. In Dover, and under Dover, we may have to deal with those as time goes forward and our project moves forward. It's the same way we'd have to deal with conservation restrictions. We'd have to comply with wetlands bylaws and the like. But under Dover, you cannot zone out educational or religious uses. You cannot prohibit them, and their bylaw does not. Even though it's restricted in other respects, building is restricted in the NR district, it cannot be restricted, and it is not restricted under section 4.10 of their bylaw. It does not restrict us, Northeastern, from educational and pursuits. So we can build it as long as we, as Your Honor points out, we comply with other applicable regulations. Here we go. Thanks.
We just need the appendix right
it's
there.
At Record Appendix 7, page 11.
Okay.
It shows the Murphy bunker and where the new construction is going to be done. It will not destroy all of the area to the east of the Murphy bunker.
How much of the 12-acre plot that, or
Yeah.
it's not, I want to say plot, but the 12-acre area that's at issue here
Would be altered?
affected by will be altered, yes.
Like 2 or 3 acres, perhaps. And the rest of it, Northeastern, as part of their plan, would restore with non-invasive species. They'd eliminate the invasive species and put in non-invasive species. It'd be better habitat, frankly, once that
Let me just ask you,
done.
to interrupt you, is there any agreement with respect to the facts that the proposed building would only affect 2 or 3 acres? Because I heard something very different from your
Is there any
brother
what?
here. Is there any statement of undisputed facts in which that is included? That
You know, I don't know
the
the
extent
ans-
of which the proposed building is going to take up
Right, Your Honor.
acreage.
I don't know the answer to that question precisely, if it's in the statement
Well,
of
we'll find
facts.
it.
But I believe Mr. Trussell's affidavit, Professor Trussell, who's the executive director of the Marine Science Center, in his affidavit does talk about what the plan is, what's going to be altered, what's going to remain, how they're going to reinvigorate what's left over, and so on.
I understand there's some dispute about what that might entail, so I
but
was
I-
wondering if it was the subject of any agreement, but that's okay, we'll.
Yeah, and I don't know that is, respectfully, I don't know that's material to the question of
I guess that's
whether
one
the
of, I
trial
guess that's
court-
one of the issues that we'll have to address.
Got it right, okay.
And you're also over your time, so
I
I'm
know,
going to
Your
double
Honor.
check with. Okay. No further questions from the
Thank you, Your Honor,
panel,
for
so
your attention.
we'll
Thank
take
you.
this case under advisement. Thank you all very much for coming today, and we'll get an answer to you as soon as we can.
Thank you.
We're going to take a brief recess. All right. So I understand that the fourth case has, everyone's here, that's great, so we're just going to take a brief recess and we'll come back out and hear the last case, okay? Thank you very much.
So we'll stand in recess.
Right under the belt, right? Here we go. Yeah. It's a 5-minute difference. How long have you been here at the court? Oh. So you've seen a lot. Oh, so this is really, I worked with the sheriff of Suffolk County. We were back in the 80s. Sheriff Rufo. Yeah. We were the counsel for the jail, the constitutional case that went to the Supreme Court on that. It was, if you remember now, the Liberty Hotel, right, was closed down. But when the new jail got open at Nashua Street, the plaintiff, the pro se, and the plaintiff said it was also unconstitutional because it was double bunked. Do you remember that? Yeah. So I worked on that for like 8 years. Very, lots of stuff out of there. There you go. You lucky. Oh, God.
All rise.
goes, no, you're third on the list. I said, oh, well.
Please be seated.
Okay, thank you very much. And now we're going to hear our last case on the list for today. And give me 1 second, and I will. Alan Smith versus Decision Corporation, 2023-0476. Thank you.
Thank you, Your Honor. Good morning, Your Honors, and may it please the Court. My name is Walter Foster, and I represent the appellant, Decision 1. The trial court below committed a clear error of law when it awarded the plaintiff damages in the guise, of course, as commissions after this April 1st, 2012 date, pursuant to a prior plan that had been superseded. So to remind the court, and this is one of the, I know you've read the records,
Lots of
but
math, we
it's
know.
our second
We're
time
ready.
up here. And it's the 10 plan. So in 2000, there was a fiscal year 2010 plan. And on our first trip to the appeals court, what this court, a prior panel of this court held, and it was remanded for damages on just essentially the 13 plan was held to be validly adopted. That is the validly adopted date. The April 1st of 2012 is the date that the 2013 plan, as it's called in the record, took effect. What the trial judge did here, and the parties have agreed throughout the trial, there's absolutely no dispute about this, no commissions were due or owing under the 2013 plan. That's done. We have a full agreement about that.
So on that, and believe me, I've looked at this record closely, and
Yes, sir.
I have some like detailed questions for you.
Absolutely.
So on the problem with the reason that there's nothing due under the 2013 plan is that it has a threshold of $2.5 million in new accounts?
Yes, you're right. So not new. And I understand your question because the trial court says, oh, this only has to do with new. No, it's all revenue. And the trial court points to a provision of the 13 plan entitled new revenue. You must look at the incentive provision on the plan.
So if Mr. Smith brings in a new client on March 1st, 2012, he collects commissions from that client for 1 month, and that's it?
So in 2012, after...
Like 1 month before the 2013
Oh, 1
plan
month
goes into
before,
effect,
yes.
he gets a new client, $1 billion account. He's entitled to commissions for 1 month, and then after April 1st, it all disappears.
So only the revenue that's booked in that 1 month. So there's a tail end, as in the real world, for all of these commissions planned that are usually just 1 year apiece. Each plan
So he wouldn't continue to collect for the 1 year's receipts on that, it'd just be for 1 month.
Right. What would happen is the way that these sales are is in the only account that we're talking about is the IBM account, is their sales are booked by month. It's not like a sale that comes in that you sell a house for $8 million and it books in that month. And so the plans are very, very clear about this. It talks about new invoiced revenue, and new is a small n. It means any new invoice revenue that comes in on April 1st of 12 or after goes under the new plan commission rates. So in 2013, there was a dramatic change. Mr. Smith received a very significant raise of $25,000 in his salary. The recalibration of that 13 plan emphasized that you would have much more of a draw and less of the commissions. And the new quota rate was $5 million. You would not get any commissions until you achieved half of that quota. Then you would begin to earn commissions. So that was how the 13 plan worked. And to answer your question, if in March a new case comes in, it goes under the old plan in 2010 for anything that is booked in March of 2012, because it takes a while for the client to pay that. So if it's invoice revenue and it gets booked and the client pays it, that is paid out according to the prior plan. When the new invoice revenue comes in on April 1st, it's now under the new one. So he gets the salesperson, gets the benefit of however, it always gets counted. It's just counted under the new plan. There's always this tail.
If on that new hypothetical client, you're going to have $5 million booked in order to be able to get any commission on that.
Correct. And you're lucky if you had a sale in this particular case. And it's very important to understand what this is. It's services to cash registers, basically. So it's like, this entire one case, and that the parties stipulated to at the original trial is we limited this to one of the salesperson's accounts. It was IBM. He had others. But it was this case from its day one in the trial and on the damages and remand is just about the IBM account. That's it. That was a stipulation made very, very early in the case and applies to this, for the damages. It's important to be aware. Those services, when you look at Exhibit 71 and Exhibit 72, which is the spreadsheet with all of the business records of every IBM invoiced amount and the dates that it was invoiced. It's completely color-coded because that's exactly what we did on remand after the first appellate court decision. And it delineates exactly all of the revenue and what counts for commissions under each of the plans. On remand, of course, the D1 had to completely recalculate all of the time during the 2012 where there was a 12 plan. It had been calculated on that, but that was held to be invalid by this court. So entirely new commission rates had to be applied. And there are 3 specific time periods. We took pains in our brief, it's in pages 42 to 48, where we break down, and the trial court agreed there were 3 what are called discernible damages timeframes. And that is because that's exactly what the 2010 plan says. So from...
And those you break down into, there's a category that you call ineligible.
Yes.
And there's a category that you call, that it's in gray.
Yes.
Right, so what is the other category?
So there are 3 errors in that part of the court's determination. There was in January to March, there was one where it was
sorry, it's non-designated.
Yes, I was doing IBM Canada first, and then there's non-designated and ineligible. So I'll go through each of those. On the non-designated, Your Honor, these are non-commissionable revenue for the IBM account. These are the produced records of Decision 1, testified to by Attorney Ross, who was there at the time, and testified at length during the damages and the first trial. We were asked and produced, of course, during discovery, all of the records for any revenue.
Why are they non-commissionable?
Because, Your Honor, they did not have to do with the sale made by Mr. Smith. So there are times when there are adjustments made or sales that fall outside of the definition of commissionable under the 2010 plan.
Okay. I'm looking on a page, Record Appendix 3, 178. You've got IBM Corp. and IBM Accounts Payable, IBM Hess Corp., and those are all that are not Smith's accounts?
Your Honor, there are, under the commissionable plan, if somebody else either helps with that account or had made that sale, that's part of the reservation where D1 makes a determination of whether it's commissionable under the plan. And the testimony that was uncontested at trial was Ms. Ross took the stand and talked about this entire non-designated account that falls within it. They were not commissionable, so they were never counted as part of any original, the gross revenue, because under the 10 plan, you look, of course, at the gross revenue.
So that's the ineligible is anything after 12 months on any particular account?
Yes, Your Honor. So the ineligible, the way that it worked, because this plan, not only during the time factually, but of course on remand, there is no 12 plan. So now there's the entire calendar year of 10, the entire calendar year of 11, and the first 3 months of 12, because the quotas only go to what those yearly quotas are. What Ms. Ross testified to at the trial, and was, again, uncontested, is that they would allow, while that 2010 plan was in place, that if he got a brand new account, and one of them I think was called Best Buy at some point, and as part of the sub-account for IBM, you would start the 12-month period on the day that you got the first revenue. So sometimes IBM would not place an order. You might have close the account, but their first order being placed doesn't fall until another date. Giving the salesperson the benefit of the doubt, all of those would then begin and run for 12 months, because that's what the plan called for.
Wait,
It was-
where did the plan call for? I mean, wasn't Ms. Ross asked to sort of identify where in the 2010 plan commissions were limited to a 12-month period, and she couldn't identify any text in the plan?
Your Honor, what she testified to is that this is the policy under the plan and how they calculated all of those commissions.
But she couldn't actually sort of point to anything in the plan that
it
said
does
that.
not. It was, there is no specific part of the 2010 plan, nor is it in the 8 or the 9 or the 13 plan, that your first time that you will get revenue will let you do it for a year is the first date that it's invoiced. What she pointed to is that the effective dates of that plan, each plan was meant to be for a year. So if the plan was continued, which the 2010 plan was, that's why she was able to provide that testimony. So the way that the plans went.
Ms. Ross also testified that commissions under one plan continue past the plan's expiration date, despite the implementation of another plan. Isn't that correct? She testified.
She did.
Right.
She did.
At least a 12-month period.
Right, at least for the 12-month period.
So doesn't that cut against your argument that the effective date of the 2013 plan kind of stopped everything with respect to commissions owed under the plan?
That's the distinction, Your Honor, was that they were giving, trying to make their salespeople happy about when they would start that. But when a brand-new plan came in, all revenue, and the way the plans are very, very careful, and the 13 plan has it in 3 places, all new invoiced revenue as of X date now falls under the new plan. And that's exactly what this court held, the prior panel of this court held. It was, here's a $25,000 raise. We are changing it up. We're changing, and companies get to do that. The unique thing that I have seen in this, the longevity.
That was just the prior panel just found that the 2013 plan was valid. There was valid consideration.
Correct.
It didn't make any finding as to
It did
the
not,
effect
Your
of
Honor.
commissions under the right. That's kind of your position.
It is, but it's my starting point. And the starting point that you go from there, and that where the trial court made an error, is it's making a decision, if you will, in its decision, that was never argued during the case about this kind of new revenue. That's never raised by any party. And the event monitor case is really on point here. There's no dispute under the 2013 plan that whether it was an existing account, a brand new account, all new net invoice revenue from that day forward would be considered under the 13 plan. It's very clear about that. And the judge takes out of context, there's a specific provision that does new revenue, but what is really the germane part is the title incentive in that 13 plan. That's where the 5 million quota is set forth, as well as the 50%. And it says right on it, it says all assigned accounts, all assigned. It's right in the incentive part. So although Ms. Ross, who, if you recall, this is 10 years after all the parties had been there, didn't have instant recollection for multiple old plans, the 13 plan has it right in it, and it's under the incentive category right in the middle. It makes it very clear that all accounts assigned. This distinction that somehow the 13 plan only goes for new, and then the 10 plan, that theory of the court would have, it happened to be Mr. Smith left in September. Under that theory, there's no end to that. There's, as long as those accounts, quote unquote, existed. We're only talking about one account. The IBM account. The services made here, there's no direct contact between the salesperson and the end user of the IBM services. It's only IBM. So all of the effort is geared towards that. There's only one account that is at issue in this case, or that was ever dealt with in terms of by Mr. Smith of the sale that he made.
So what's the distinction on
turn has its own.
So you mentioned earlier that there was eligible commissions on IBM Best Buy. Is that?
If you look at Exhibit 71, which has all the wonderful color coding, what of course D1 did is they kept track of each of the individual bookings, the revenue, and IBM identified them as IBM Best Buy, IBM Sears Kmart, IBM Hilton. So it's IBM's clients. And that we kept them, meaning we, D1, we keep track of it. So those are listed that way. From a commissionable revenue, Mr. Smith was able to aggregate all of those to me, and that's
But
why
for the eligible period, for the 12-month eligible period, that would, like the new Best Buy thing, that seems to be, that's counted as a new account for that purpose.
It's not under the commission plan at all, Your Honor. D1 and the sales made, because all of those numbers were added together. You can't have it both ways. But from a D1 perspective, those were always just one account. So for instance, the threshold...
But it goes from green to yellow, in D1's mind.
Right. No, but it's just a new invoice from IBM. IBM says, I now need these services. It's going to be directed. And when you have a huge client like IBM or Google, you keep your records and track it for exactly what the purposes of that business are.
I'm sorry to interrupt you, but I've got a lot of questions still in the...
Oh, certainly, Your Honor.
So you're saying, my understanding, so when IBM starts a new Best Buy, a new use for Best Buy, that has nothing to do with the salesman?
It does. The salesperson has gotten it through IBM. They have talked to them about it through the IBM representative. Okay. So it gets added, but it's all the IBM account for commissionable purposes.
Can I ask you, what's under the 2010 plan?
Yes.
What is renewal revenue?
So renewal would be an existing account under 2010, an existing account, and then they have another new order. But the account isn't brand new as a new logo to D1.
So, but how can I tell by looking at the charts what's new and what's renewal?
You'd have to look at all of you mean the chart Exhibit 71, Your Honor?
Yeah.
You would not. That document doesn't show it wouldn't show, all that it shows is a certain period of time because of the damages time period here, but all of them are IBM. Okay, so and you'd have to be able to look at 8 and 9 to say what's renewable for that.
Okay. There's something about on Smith's PSP.
Yes.
There's a quota for pre-existing accounts where the renewal revenue comes in of $955,000. Is there nothing that's subject to that part of the agreement? Is he entitled to any renewal revenue commissions?
In the 2010
in
plan?
this entire case, yeah. I mean,
yes, he was, Your Honor, and I believe he met that quota, and that was where part of the payments were made.
And is that commission a higher level, 2.792?
It is. The renewal quota had that quota of 954,000, and it had a threshold that up to the 3 million was 1.33, and then over that was the 2.97.
So the 954 and the 3 million, those are related somehow?
It's 2.972% up to the 3 million. Okay. As a threshold level. I don't think any salesperson ever made it beyond the 3, so that.
Okay. And his PSP, there's a copy of it.
Yes.
Page 18 of Record Appendix 2. It's totally illegible. Is there a legible copy of that? Of his PSP?
Yes, Your Honor. I have it right here in front of me. It's a little bit fuzzy, but it is legible to me. And I know we did supplement the record with other.
If you could provide a copy of that.
Absolutely, Your Honor.
Our clerk's office.
Yeah, we find this pretty legible and happy to present that to the court.
Can I ask one more question?
Absolutely, Your Honor.
On the summary chart, it's RA 4 or 3, I think, the beginning of the yellow and green one. Hilton's broken out. What's the deal with Hilton?
Hilton was in the testimony at trial was that Hilton came in as one of the IBM sub-accounts, but hadn't been ascribed to him, and there was a dispute between the parties, and then D1 said, yes, Hilton is part of this. So it's not uncommon that because for instance, in Mr. Smith's case, the IBM Canada is a great example. There was an entirely different salesperson, Peggy McNamara, who had all of that, but D1 had incorrectly been carrying that in his. So there were all these cleanup. The time period for that, I believe, was the fall of 11 or the fall of 12, when Hilton came in as a new subheading or sub-account, if you will, of IBM. And so that's why that's carried that way.
And last question that I have, why was, at the first trial,
yes,
why was Mr. Gall's calculation $60,000 over?
Absolutely, Your Honor. Because all of those calculations were under the 12 plan. We're under 3 plans. So the calculations at the original trial, our position was we had paid Mr. Smith every single penny. We accounted for it at the original trial under 3 different plans. At the appeals court level, the 12 plan was held to be invalid. We obviously disagreed with that. That was the holding of the court. So when it went back, that's why the appeals court, we asked the then appeal court panel to send this back, is because you had now had to take all of that revenue, you had to allocate it by the commission structure in the 10 plan, which D1 had never done before, needed to be done, and it came out completely different. And in fact, Your Honor, to us, the facts really are very compelling. With the holding of the prior appeals court, recalculating those revenues in 12 resulted in a $60,000 overpayment. That's why.
Whose appeal was the first appeal? Was it Smith's appeal or your appeal?
It was D1's appeal, Your Honor. The original...
Were you trying to get the 2012 invalidated?
No, not at all. The trial court
would have been in your interest to, apparently.
I'm sorry?
It would have been in your interest to, apparently.
No, it would have, but we didn't know that because we didn't know what the numbers were. We took the position in the trial court and lost that all 3 plans were validly adopted. The 10 plan, the 12 plan, and the 13 plan. Trial court said, 12 plan, 13 plan are out. The appeals court said, oh no, we agree with you with the 12, but the 10 and the 13 plan, those are all in. So that's what left it quite frankly, is a very unique procedural posture, but that is why there's a $60,000 overpayment. It's a recalculation that had to be done under the 10 plan, which we did.
Okay, I'm sorry. I had one more question that I found here. The judge's findings, with respect to this disputed period of time from April 1st to September 5th of 2012, there's a footnote there where he comes up with a number which I think agrees with your $5,000 math. It's in footnote. It's on page 4, footnote 7 of his opinion, and that he says the number from that period, from the supported by Exhibit 71, is $4,312,806.10. Do you agree with that? At least you don't agree that it should have been counted, but do you agree with that calculation?
And Your Honor, can I ask you, can you tell me the time period again? My apologies.
It's April 1st forward.
Yes, I do agree with that number, Your Honor. Yes, thank you. That's why we divvied them up for the April 1st time period, but I do agree that moving forward, that is the number.
Okay, thank you.
Thank you, Your Honor.
Thank you very much.
May it please the court, my name is Christopher Trundy, and thank you for your indulgence. I realize I was out of order and late today. Let me just say that we disagree fundamentally about the nature of the appeal. There are detailed factual findings here on damages, and that to overturn those, generally, this court would have to make a finding that it was
Clearly erroneous.
not abuse of discretion, but a significant violation on the part of the judge, clear error. It is framed, these things are framed as legal arguments. I do not believe we're talking legal arguments. Now, to go back to the last time we were here, this judge heard the testimony over several days. made a series of findings, and one of his observations was a legal issue as to the viability of the 2013 plan in light of the subsequent termination of Mr. Smith, and whether or not that was in and of itself improper. The appeals court at that time said, that's not the law. We're striking that as a matter of law. They then remanded the matter for further determination of damages. Now, they never waded into the damage calculations, and I think it was a fair thing for them to do because it was not clear to everyone, certainly, whether or not the judge was awarding any damages under the 2013 plan, or whether or not any commissions for activities after the start of the 2013 plan fed into the damages that had been awarded. So when this case came back to the trial court, the judge had us confer with him, and the plaintiff said, we do not think there's a need to reinvestigate damages because we all know from our experience in the trial court that there was no 2013 underlying revenue that supported the damages calculation. The defendant asked to reopen damages, which the court allowed. At that point, there was a difference in posture in terms of analysis because we were all working with 3 plans. We didn't know what the 2013 plan's meaning might have been. We assumed that, as the plaintiff, we assumed that the 2013 plan would be invalidated by the court, which it was, at the trial court level, and that finding of fact was deferred to by the appeals court. However, we did not feel, as plaintiffs, that it made any difference, that it was going to change anything. The difference was that when we resumed the multiple-day damages hearing, that D1 provided the court with an Excel version of a ledger sheet, Exhibit 71, I believe it is, which was largely unintelligible to us as parties and to the court at the time, and we were working with certain other documents.
You made me feel, I don't feel so bad now.
What's that?
I don't feel so bad now.
Right. Oh, no, no, and it's nobody's fault. I mean, these documents, this case went on a long time, documents were copied and copied again. But, you know, in any event, the submission of that document allowed us to do in more precise form what we were doing in more rudimentary form based on, and everything in this case, just as an aside, everything in this case is based on documents provided by the defendant. This is all of their records.
But do you have the same explanation of why their employee Gall's calculation was 60,000 in your favor?
I don't think, quite frankly, our view is that none of the calculations were correct. There's not a single calculation in this case that we can look at a month's worth of revenue or invoices or whatever and program that out and say this makes sense here. Mm-hmm. What the testimony was at the trial level was that Smith was saying, I'm entitled to money, and they would issue him checks. And nobody could tell what the number was. And that was part of the challenge in the discovery process and at the trial court. And what we have, and it was part of what we argued to the trial court and to the appeal last time, which is that there was not precise information as to how to calculate Mr. Smith's earnings here, and that the lack of that information really falls on the defendant for not providing detailed information. So we worked, when you have a trier of fact working with incomplete information, that becomes their decision. And I think what you see, in all honesty, this judge who sat through effectively 2 damages trials here waded through an extensive amount of information and did a very workmanlike job, in my opinion.
Can I ask you about...
He did not give us, by the way, what we asked for.
Okay.
On remand, and he did not give them what they asked for.
So
He made an independent
can we
decision.
talk about the 2013 plan?
What's that?
Can we talk about the 2013
Sure.
plan?
Yes.
I mean, the parties agreed that, I think you agreed, right, that you stipulated that your client did not earn any commissions under the 2013 plan.
That's correct.
And yet when I looking at this case before I got to oral argument, it seemed to me, well, that seems pretty unfair. My hypothetical, he gets a new client in March of 2012, and then he only gets 1 month of...
Well, that's not what we stipulated to, though.
So their answer was, he would be, if that new March account got over $5 million or $2.5 million in 2013, then he would get commissions under the 2013 plan. And you're saying he's not eligible under the plan, under that plan, but he is eligible under the prior plan.
So, yes, and it has always been the defendant's claim that at any time they could terminate existing commissions retroactively. That's what this case has always been about. That in 2000...
That's not exactly what they're saying. They're saying he could still get commissions on that, only
they
at a
didn't
different
say
threshold.
that at trial. So let me just address that. Scott Gall testified very explicitly at trial that the purpose of the 2013 plan was to strip Alan Smith, who had gone out of his way for over years to cultivate this relationship with the world's largest servicing company, IBM, for all these multiple IBM accounts. And that the purpose of the 2013 plan was to strip him of ongoing commissions, which is why there's no mention of pre-existing business in the 2013 plan, as the judge noted in his decision. So what their claim was, that's a black line. That's a line that at that point, everything stops. All of your earnings, all of your effort for years to build up millions of dollars worth of income stops because we can come in and give you a new plan, and moving forward, here's an extra 25 grand. And we're going to strip you of hundreds of thousands of dollars worth of earnings.
I interrupted you. What did you stipulate to?
We stipulated that under the terms of the 2013 plan, from the date it started, April 1st, going forward, he did not reach any thresholds for new business. Now, what we argued was that these were pipeline commissions, that he had earned the commissions because each of these sub-accounts at IBM, as you can see in the record, start at certain dates. So you'll see IBM Best Buy, and it starts month by month by month. And in fact, in 2012, when Mr. Gall was administering the plan, he administered each of those as separate accounts. And that's seen in many of the documents that are in there. It was the revelation, of course, when Sandra Ross testified, who had no personal knowledge of this, but testified at the renewed damages hearing over our objection, by the way, and told the judge quite directly that, no, you can't stop the earnings, that the work that you've already done, you've earned that business, you get paid on that into the future. And in fact, the 2008 plan that's in your record and states that, and there's testimony and admissions, which I think are alluded to in my brief, where under 2008, there was no 2009 plan, but 2008 and 2010 both anticipated that there would be carryover commissions, that we would owe money over 2008 during the period of 2010.
Can you explain to me, just in layperson terms as much as you can,
Yeah.
what's your position? What revenue counted in terms of carryover commissions under the 2010 plan, and what revenue counted for the new invoice revenue under the 2013 plan? How do you distinguish between those two categories?
If the account began during the effective period of the 2010 plan, which became on remand from 2010 to March 30th, I guess, of 2012, if that account, that sub-account, and we don't agree with this claim that IBM is one account. These are all multiple sub-accounts. But you'll see there are trailing reports, which we used for our calculations at the first trial, which show that on a certain date, a certain month, this account starts. IBM Best Buy, IBM Kmart,
And you'll see that these things start. And that money is added up individually, up and continues on until they disappear. Sometimes those accounts just run out. And so if you start the account during the effective of the 2010 plan, you get the benefit of the 2010 calculations because now 2012 plan was not properly administered.
How long can those accounts continue?
Well, the judge effectively continued those until he was terminated. I think, in retrospect, I think the commissions were probably owed and should have been, paid past that date. But I think that's the judge took a conservative position for that. But, I mean, I think the position here has been, and I think it's legally erroneous, to say that I want you to go out and build this book of business. And once this business is in the pipeline, then what we're going to do is moving forward, we're going to cut you off using this 2013 plan, which was by their own witness said was the purpose, was to cut off Smith, who was the lead salesman. He was the big guy here. This is a big deal, this IBM business.
Were there actually new accounts that were brought in after April 1st, 2012 that Mr. Smith did not achieve any commissions on because they came in?
I'm sorry, I couldn't.
Were there new accounts that were actually brought in between the period of when the 2013 plan went into effect and he got terminated? Were there new accounts that would have counted towards the?
No, there was nothing. There was nothing that I'm aware of during that period. That is in our record.
April to September.
Right, that is in our record.
So he didn't make any progress on.
That's why, and we weren't focused on that.
Okay.
The claim.
I'm just curious in terms of he never made any headway on towards.
Well, he had
commissions.
of course, they gave him a modest increase in base salary, and they went from 1 million, 2 million, up to 5 million, and he still had the obligation to service the existing business. Although theoretically their claim was he couldn't be paid for that, but he had to handle it. But our record has no evidence of what business was started under the 2013 plan. There was also, not to get too deep in the weeds here, but there was some issues.
Go right ahead.
Well, because the 2013 plan doesn't actually get disclosed to him until after some date, and then there's an acceptance period. And then he's fired like 6 weeks after he signs the plan. But we never sought to collect under the 2013 plan. Nobody put any trial evidence in as to what revenue D1 obtained from Smith or Smith's team or whatever it was relative to IBM under that plan. And we never went looking for any money. We never went looking for money under the 2013 plan anyway. We were really looking for that large block of money that really kicks in early 2012.
My recollection of the record that one of the earlier plans, the 2008 or 2009 plan, says that you earn commissions on a new client for 3 years. And then in the subsequent plan, including the 2010 plan, there's nothing at all about it. And so your position is that by removing the 3 years, it became forever. And their position is by removing the 3 years, it became 1 year. Is that?
I don't think there was a limitation. I think the judge commented on that in the decision that there was a change. Now, there's no 2009 plan.
Okay.
This is, you're going to, welcome to our world.
The 2013 plan starts in 2012.
So there's a 2008 plan, no 2009 plan. There's a 2010 plan, which got modified because there was a change in the fiscal year, and then the 2012 plan gets dissolved at the first trial, and then the 2013 plan. I'm out of time.
I've got two more questions for you.
Sure.
Do you agree that your client is not entitled to commissions for the Canada account?
No, we don't agree to that.
He is entitled to commissions for the Canada account.
And it's unclear, I believe there's testimony on that everything, what he testified to was that he reviewed all of the transactions that show up in the Excel spreadsheet at, I believe, Exhibit 71, and he informed the judge that he was the primary salesperson on those. Now, how there is some question as to how those things break down, because they're not broken down by month the way the trailing reports were. But his testimony was, and the judge was entitled to credit that he procured everything that was in that exhibit that the judge ultimately relied upon to make his damages determination.
And an example of a trailing report, is that Exhibit 3?
Can you help me with that? Do you know that? We've had a long-standing relationship.
One friend and one
so-
lifeline, I think that, yeah.
If you could just,
A trailing report.
it's called 12-month trailing reports,
It's Exhibit 8
Exhibit 8.
to,
Okay.
on the trial.
Thank you.
And it may appear, I think it appears multiple times, but those with the original documents, just, you'll see in the trial transcript that my client relied upon based upon representations made by him. Mr. Gall told the court at that time we should go look at Exhibit 71, that's better. And then on remand, we followed Mr. Gall's mandate. Everybody we all focused on Exhibit 71. And so that was thoroughly examined by the judge, and I would just say that.
And your answer to my question earlier, that why Mr. Gall got it wrong, why they say he got it wrong by 60,000, is because you have an idea what he was relying on, basically.
It is so confusing how these commissions were arrived at. There's no rhyme or reason. I wish I could say this case would have been different, I think, if we could have been able to say this, we can see that this revenue came in and this number followed, but there's just no rhyme or reason, so all we could do is look at it is in terms of large blocks of time, year at a time or whatever, and that's what, we looked at it as 2 separate periods of time, they looked at it as 3, the judge, I think, went with 2010, 11, and 12 being 3 different discrete periods, and that's how he calculated it, as best I can tell. But it's a damage calculation by a finder of fact, and we think he's entitled to your deference. Thank you.
Okay, all set? Well, thank you all very much. We appreciated learning about how your business works, and we'll take the case under advisement and get an answer back to you as soon as we can. So court will stand in recess, and we'll come back out in a few minutes to speak with Justice Granger's students.
All rise.